Χρειάζεται τόλμη και ρίσκο κάποιες φορές για να κάνεις κάποια πράγματα. Αυτό που λέω και για τη δικαιοσύνη είναι ότι χρειάζεται τόλμη να βγούμε έξω από το κουτί. Και για το συναισθούτιο μου είπα σήμερα είναι η πρώτη φορά. Θέλεις να ρισκάρεις κάτι να μην πάει καλά και τους λέω γιατί όχι, αν κάτι δεν πάει καλά θα υπάρξει κατανόηση από το κοινό. Και επίσης θέλω να ευχαριστήσω τον Αχιλλέα για αυτά τα provocative σχόλια κάθε χρόνο που πιστεύω ότι είναι απαραίτητα. Πιστεύω ότι είναι η αμφισβήτηση που παίρνει μπροστά την ανθρωπότητα και αυτό που εξασφαλίζει ακαδημαϊκή ελευθερία, να μπορεί κάποιος να μιλά ελεύθερα και βέβαια καλόπιστα να ασκεί την κριτική του, είναι πάρα πολύ σημαντικό και πιστεύω τα τελευταία χρόνια στην Κύπρο τώρα άρχισε να γίνεται. Και αυτό θέλουμε να κάνουμε και εμείς, δηλαδή είναι αυτό που λέγεται για κάποιους ότι είναι friendly critics and critical friends. Θέλουμε να είμαστε φιλικοί κριτές και σημαντικοί φίλοι σε κάθε προσπάθεια. Άρα ελπίζω έτσι να αντιμετωπίζονται και οι εισηγήσεις μας από τους θεσμικούς παράγοντες. I would like to invite now Professor Alan Uzelac from the University of Zagreb and a leading figure in the European civil procedure, who is going to be our keynote speaker for today. And welcome to Cyprus, and the floor is yours. Να πω, αν χρειάζεστε μετάφραση από τα αγγλικά στα ελληνικά, μπορείτε να πάρετε ακουστικά από έξω. Υπάρχει ταυτόχρονη διερμηνία. You need to click this twice. Yeah.
Click it.
The Greek button twice, I think.
Well, I think it's going here, but
Yeah, but it doesn't show there.
You just have to.
Once more? Once more?
Yeah.
Okay, there we go.
Thank you very much. This is an excellent place for a keynote that I'm going to deliver. It is a wonderful room. And, well, I hope that my presentation is going to be placed, well, I can see it over there, but it has been placed on this side here. Well, first I would like to thank the organizer, and in particular Professor Kyriakides, for this kind invitation to deliver this speech, and I appreciate very much the efforts of the Procedural Law Unit to establish a conference which is dedicated to the key problems of modern administration of justice. And as we all know, these problems are not only national, they are more and more the problems which we cannot resolve unless we join forces and undertake comparative research of the best and sometimes also of the worst practices. And insofar, Professor Kyriakides and his colleagues are undertaking in this third annual symposium something that is very much compatible with what I have been doing recently and not so recently in the past 17 years in the series of conferences in Dubrovnik where the two of us met and where also Professor Kyriakides delivered a very insightful presentation on a topic which is very much of the interest of this conference, that is the court experts. So I was very eager to accept his proposal to come here and deliver this keynote speech, and my excitement is twofold as I stand here for the first time on the beautiful island of Cyprus, addressing you on the topic that was at the heart of my work within the project of the Max Planck Institute for Procedural Law and the International Association of Procedural Law. It's a project on civil procedural law and justice which is dedicated to crafting a comprehensive global encyclopedia or compendium of civil procedure, and in particular comparative civil procedure. What I deal with within that project in particular involves the comparative exploration of the evolving notion of a court. And as this conference is devoted to the court of the 21st century, I will shed some light on the profound changes that the concept of a court has undergone in recent times, a rather general area. And these transformative shifts challenge the conventional perception of what are modern courts and prompt us to contemplate whether even that perception is in part antiquated today. So I will guide your attention a step further, exploring the contours of what a postmodern court might entail. And in this context, I pose the question of whether we are on the brink of a paradigm shift, and this paradigm shift is something that is coming perhaps not today, but it is certainly coming in a not so distant future. But let me start with some illustrations. How do we imagine, how do you imagine what is a traditional or a pre-modern court? And I would like to share with you my perception. And this perception is a photo which is copied from newspaper coverage of the strike of Croatian court personnel, which took place this year and lasted more than 3 months. And these are actually not the old photos, they are only a few months old, and they demonstrate that in many places in Europe, courts are still operating in a rather old, paper-based way. Our courts are also perceived as places which are plagued with inefficiencies that arise from the outdated nature of such practices. And the two keywords which have always been mentioned in the context of the problems of Croatian judiciary, and I see that Cyprus has been having that as well, are the issues of backlogs and delays. And of course, we can see here clearly why they are so pronounced. But let me then imagine also what a modern court would look like today. And again, many of us would like to see a rather modern, functional, and almost impressive picture of modern court facilities. So let me show you one. This building here is the building in Los Angeles, which is obviously the pride and joy of its architects. And many of us would think that this is how the court today should look like. But I would ask you whether this is really the case. It may come as a surprise that in many courts like this in the United States, very little of conventional judicial work is going on. In a recent study of American scholars, it is established that court trials in individual litigation cases are virtually disappearing. And in a court like this, you can, for example, find that in the whole calendar year, not more than 6 court trials take place. Thus, what we need to re-examine in our postmodern times is the meaning of a court in the 21st century. What used to be a court in history and what it is supposed to be in present time. But before going through this, I would first ask a computer to tell me what a court is. And this is what the computer responded when I asked the computer to tell me what would be an appropriate icon for a court. So what we get here are 4 different symbols which are associated with 4 different ideas. Once court is a building, then court is a symbol of power, then we have a human adjudicator, and then we have an ideal outcome, which is a balance or justice. So can we find a new cross-cultural meaning for a court in the 21st century? In order to address this question, I will start with some initial observations regarding different connotations that have been contained in the notion of a court throughout the history. A closer study reveals that there are at least 7 different layers encapsulated in the notion of a court. And they exist equally in the English expression court and in other words, in other languages like Cour, Korte, Gericht, Sud, and the others. So to make our speech more language neutral, despite contemporary despise for Latin language, I hope Greek is still on the agenda, in my slides I will use Latin as the language, which has not only influenced legal culture of many countries, but also as the language which can best uncover divergent connotations of the meaning of a court. So let me start with the first layer, which is also the most traditional one. It is the court as a place. And this spatial connotation of the word court exists at different levels. Both the English, word court and one of the Latin words for court, and this is the word forum, they denote a place. And we may also add a public or at least semi-public space. The forum was in antique times a square populated by citizens, a place where life happened, but also where important decisions were made and were announced. So the word court also nowadays describes a defined space, a courtyard. And in modernity, court is also often understood as a distinct location, as a court building, as a place purposefully built and arranged for dispensing justice. And territoriality also used to be an important connotation of the notion of courts. But civil justice is changing and transforming, so the courts started to transform as well. So for instance, to emphasize that court can also be something else, the CEPEJ started to use the expression court and the expression geographic location of the court to distinguish this meaning from other meanings of the expression of a court. The second layer is partly connected to the first one, but it is still distinct and different. Just like the Roman Forum was the place where community would gather, the original understanding of the court was also connected to the idea of a community. An explanation of etymology of the word court or cour in French points to Latin expression cohors, which refers to a group of people who live together or serve together in a military unit. And this layer of a court as a community indicates that courts reflect social values and that they need to enjoy popular trust. This can be achieved either by issuing decisions that have democratic legitimacy or by other methods which secure that courts decide in line with popular beliefs and convictions. And the notion of court as community also expresses the need that courts work in the interest of the community, that they provide useful solution to the conflicts, and this solution can often be in the form of compromises reached through alternative ways, for instance, by negotiations or by mediation. The third layer brought in the notion of a court is of a more recent nature, and it is partly in contrast with the previous one. At least from 14th to 20th century, courts were in close symbiosis with the secular power and later with nation states. As holders of power, the courts have imperium. In the technical sense, this layer understands courts as administrative institutions, as organizations which host judges and other ancillary staff which participates as a branch of state government in discharge of functions assigned to them. And this is also a layer that understands courts as a part of a hierarchically organized judiciary. The next layer deals with the function of courts and addresses their essential purpose. Every code of procedure, in particular civil procedure, at least in Europe, understands court in the sense of an individual body, a tribunal, which performs a specific duty which only judges can perform. If such a body is a sole judge, then the court is effectively a iudex, a sole judge which has sensation time, the hard task and social privilege to exercise jurisdiction for deciding disputes in civil matters or to impose sanctions in criminal cases. And this essential function is not the domain of an organization. It is the difficult and responsible activity of adjudication which is performed by courts as adjudicating bodies. And today also the right to a court, the right to have a case decided by an independent and impartial tribunal is a part of human rights guarantees which are proclaimed in Article 6 of the European Human Rights Convention or Article 47 of the European Human Rights Charter. In the fourth layer, the court is auctoritas. It is a legal authority. As the only body which institutionally has the right to be right, the court is interpreter and sometimes also producer of law. In this role, the court is again the agent of the government, but rather different from other branches of state power. While the legislature produces laws, the courts are the only final authority which makes sense of the law. The courts contextualize abstract rules in the concrete situations of daily life. Everybody is bound to obey and interpret the law, but only courts, in particular the highest courts, may interpret law with authoritative and sometimes even binding force. Another aspect of the notion of courts more belongs to the future than to the present time. Civil courts belong to civil justice, and civil justice in contemporary societies belongs to a series of public service for the citizens, just like health or education services. Courts have a mission, and this mission is their public duty. It is their officium. This layer emphasizes the need that the courts in many segments of their work don't need to rule, but to serve the society. In order to justify their raison d'etre, they need to provide useful services to their clients. Citizens served by the judicial system need to be received by the courts as users and not as objects of court actions and activities. To serve the users, the courts need to perform. They need to satisfy pressing social needs. And this is the connotation which I will especially raise as important connotation for the court in the 21st century. And last but not least, this is a layer which was always with us and which will always, hopefully, be comprised in the notion of a court. This is the layer of justitia, the layer of justice. It expresses the idea that the courts need not only provide a decision which is in line with law, which is functional, efficient, and quick, the courts also need to provide fair and equitable solutions to the problems that they are due to resolve. The equitable solutions are only made possible if the court provides an equilibrium, and that is that the scales of justice are in balance, and if the adjudicator is independent and impartial. At the level of individual case processing, this equilibrium should guarantee fairness in decision-making. At the general level, the equilibrium consists in the role that the courts have the system of checks and balances, and the courts supervise and moderate other branches of government and secure that other bodies do not exercise their powers in an arbitrary and uncontrolled way. So, in order to find what the courts should be in the 21st century, we need also to see what main features can be attributed to the courts of 19th and 20th century, at least from the perspective of civil justice, which is my field of expertise. And I will briefly just list some of these features. First, the courts are conceived as state-centered bodies which are established for prevention of self-help. They are perceived as a branch of state power, and they are organized as hierarchical and bureaucratic organizations. Second, their default function in the civil sphere of jurisdiction is litigation, and litigation is perceived as the standard method of dispute resolution and as a principal way of access to justice. The main focus within courts is adjudication, its application of law on the established facts in a proper way. Other values like satisfaction of interest or effective dispute resolution used to be secondary in nature or did not exist at all. Court is also conceived as a place where individual issues, disputes between individuals and legal entities or individual non-contentious matters are being processed, whereas all collective forms of relief either do not exist or exist only sporadically. Most key activities in the courts and generally also within civil justice are performed by high-level professionals such as judges, lawyers, and notaries, and the court work is exclusively conceived as a human low-tech activity of case processing. So therefore, qualification required by court personnel at the higher level, it is generally legal education, eventually some classic education in social sciences and humanities, whereas the technical knowledge or use of high technology is generally disregarded or even despised or prohibited. And another feature of an old understanding of civil courts is creation of a single procedural track for all kinds of cases, and the so-called one-size-fits-all procedure. And this assumes the existence of a single model of procedure with only slight and usually insignificant variations. The focus in this model is on correct outcomes and not on proportionality. And very little attention is provided to whether time and cost correspond to the social usefulness and rationality of the achieved results. The central focus of court procedure is on elaborate technical rules contained in voluminous civil procedural codes which offer little flexibility in adjustment of procedure to the needs of the concrete categories of cases. So these are the features of the old understanding of courts, and especially civil courts and civil justice. All these features are nowadays changing. In a research project which was entitled Transformation of Civil Justice, which I coordinated some years ago, the main purpose of research was to identify and systematize the main trends of change in civil justice systems in the 21st century. The results of this project are published in an edited book, which is published with the Springer Publishing, and you can read it much more extensively. So I will just briefly note what are the 7 processes of pervasive change which have been identified. The changes that raise almost to the level of a significant metamorphosis. These 7 elements noted here are one pointing to the interconnectedness of systems and much more intense borrowing instead of particular national development of courts, establishment of multidimensional procedures, more important emphasis on speed and costs, reorganization of courts and a redefinition of court functions, intense pursuit of alternatives to litigation, much more pronounced role of technology, mostly in the form of digitization, and the collectivization of decision-making process, introduction of collective redress in different forms from US-style class actions to recent introduction of European forms of representative suits. Finally, there is also a trend to outsource certain activities which were traditionally a part of court jurisdiction. They are being either assigned to private or semi-private non-judicial actors, and this trend happens both at the low-end scale, where we outsource small claims and consumer disputes to non-judicial bodies, and at the high end, we see important international commercial cases increasingly referred to arbitration and other dispute settlement methods out of the state judiciary. So out of these main trends of transformation, I will only deal here with 3 challenges which are connected to reorganization of courts and redefinition of court functions, because they are most pertinent to the topic of the speech, the postmodern notion of courts. The first challenge is the diversification of court structures. And in order to address it, we need to explore the diversity of court structures which exist in contemporary jurisdictions. I also know that my time is short, so I will actually only show you briefly how the court structures are being organized and what issues have to be taken into account. And we see that we live in a quite multifaceted universe in which many parallel reform processes are happening. So transformation of courts happens at rather different speeds, somewhere at the speed of light, somewhere modestly, and somewhere not at all. It is therefore hard to find uniformity. What is understood as a court of 21st century may be extremely different, as for some jurisdictions, the court of 21st century still resembles much the courts of 19th century. But while differences of structures are factually still great, there are undeniably some common trends. And one of these common trends is at the same time a challenge in itself. It is the fact that courts in the 21st century cannot anymore live in an isolated universe of individual nation-states. The world has become too interconnected and too complex for simplistic concepts which perceive courts as autarkic bodies of sovereign power of nation-states which can develop entirely independently from developments elsewhere. So even if we dwell within the systems of national judiciaries, the usual concepts of courts is also changing. Courts generally become more and more lawmaking institutions. The border between judicial interpretation and political activism is getting increasingly blurred. Everywhere the courts are pressed to open their doors to alternative dispute resolution in particular to mediation. And courts are also forced to cooperate with private dispute resolution institutions and individuals. Therefore, the line between the court personnel and outside player, the line between insiders and outsiders is also gradually disappearing as the courts start to realize that they need to employ and to cooperate with more and more diverse staff, including mediators, psychologists, social workers, auditors, sociologists, IT specialists, and others. In some elements, especially in plurinational and multicultural states, the court system is progressively losing its connection to a single nation state. For many states, an exclusive and uniform national judicial system simply does not exist. Insofar, in some regions of the world, we get both common court systems for several states and separate court systems for single states. But beyond developments in particular regions, there is also a general trend of internationalization of certain standards that courts in all jurisdictions need to satisfy. At the global level, the United Nations are promoting the vision of a world that is rooted in universal respect for human rights, dignity, rule of law, justice, equality, and non-discrimination. And in this context, one of the goals of the UN 2030 Agenda for Sustainable Development is to make sure that all systems provide appropriate access to justice for all and build effective, accountable, and inclusive justice institutions at all levels. These general goals are being further elaborated by transnational courts at regional level. For us here in Europe, the Strasbourg and Luxembourg courts are the most notorious examples. And instead of elaborating on the work of these courts, I will only point to the impact of this development on the mutual relationship between courts in the postmodern world. Instead of hierarchical relationship, both at supranational and at the remaining national level, we get a more complex relationship of coordination and dialogue, which demands new methods and requires new habits within the conventional court structures. They were used to hierarchical system. Anyway, the survey of changes which affect the modern and postmodern notion of a court will be concluded with the one maybe most important challenge, and this is the challenge of transformation of courts into institutions which provide genuinely useful service to the public and the society. A request that the courts be conceived as a public service can be heard almost everywhere in the world. Here, for instance, on this slide, you see that a change which transformed courts from geographic places into services is pleaded by the President of the Caribbean Court of Justice. Two developments have in particular facilitated this development. One is digitization and virtualization, and this is the shift from courts as physical places to digital public services, which has most prominently and most citedly been promoted by Richard Susskind. The other development is of more recent time. It is the COVID pandemic, which has accelerated and facilitated virtualization of many aspects of court work, in particular in the periods when courts as physical places were prevented from operation. After the pandemic, as proved by recent research on the impact of COVID and evolution of court practices, one book is over there, new practices have a tendency to stay. Thus, it is undoubtful that the notion of courts in the 21st century will move away from identification of the court as a physical place or a single building in which court operations take place. And this erosion of the old notion of court can be divided in three directions. The first one deals with severance of ties with the court locality and court administration. With new technical tools and digitization, why would one court need to have a classic administrative organization? With virtualization, there is no need anymore to have one central place with one president, one court manager, and one office localized in one particular place. Thus, having one seat of the court becomes not necessary. But there are also further consequences. In the contemporary world, it is legitimate to ask whether it is really necessary to have a judicial organization in which each unit has a separate territorial jurisdiction, and in which each territorial competent court has its own logistics, own buildings, own secretaries, and own bailiffs. IT system, and so on. Better possibility to travel, which is present nowadays, and also the possibility of distant hearings question the need of multiple territorial units, at least at some levels of jurisdiction. And new trends in judicial administration is to use and efficiently share resources. This same trend of unifying administrative and case management structures with a view to achieve synergy is to be seen in the field of specialization. Specialization is conventionally seen as a double-edged sword, but within new innovative structures, specialization can be enhanced by unification of organization and case management. There is a movement towards internal specialization. For instance, separate criminal, civil, commercial, and family courts lose their purpose if specialization is equally secured by such departments within the court, with even higher level of specialized expertise, but with more flexibility and with the common use of shared services from court staff and rooms to digital case management systems and tools. And finally, at least for some cases, for instance, for consumer and small claims cases, we may legitimately ask whether physical courthouses and courtrooms are anymore necessary. Some countries are debating creation of a fully digital and partly automated system of civil dispute resolution. For instance, in England and Wales, Geoffrey Foss, the current master of the rolls, the successor of Harry Wolff, at present advocates transformation of English civil justice into an integral, holistic online dispute resolution system. This would be a system where all aspects of the dispute resolution would be digitally based, arising from digital rather than paper documentation, submitted electronically, served electronically, presented electronically, deliberated digitally, as a full-fledged virtual or online court. And indeed, there would always be a space and need for some classical hearings in open courts, but such cases seem to be reduced in the future to only those matters and cases which would really deserve such a treatment. And they are likely to get much fewer in the future. Just like the number of people who listen to vinyl records is much smaller than the number of people who listen to streaming musical services, we can expect that there will be fewer classical hearings. Insofar, we can expect that the courts in the future may look, or at least many court buildings which are present today will look in the future like churches look today in secular countries. They look as magnificent and appreciated figures of past monuments of the glorious times. The now emerging paradigm of the court in a postmodern state therefore perceives courts as a public service that operates within an integral system of dispute resolution. Such a system demands central monitoring, but this monitoring should be inclusive and collective. At the same time, the court operation should be focused on the user-friendly access for the users, which includes a facilitated access both virtually and locally. To achieve this, courts need to optimize the ratio of generality and specialization, and this is most easily achieved by specialization through internal specialized units, like divisions or departments. Integration in the system is best achieved by a single digital case management and court administration system for filing, service, processing, analyzing, and monitoring of court proceedings. However, all facilities, the staff and personnel which can rationally be utilized by multiple court structures should be available as shared resources for the best efficiency of the system. So, is this new paradigm of the court realized in any particular country? So far, we cannot single out a perfect example, but just to finish up with some examples and concrete figures, I will refer to some cases of successful reforms. First of all, starting with Portugal, which is a country of 10 million people, which has successfully reduced its court structure from 233 courts to 23 courts and 5 courts of appeal. The whole management of the judicial system in Portugal is now being in the hands of High Judicial Council, and the High Judicial Council is appointing presiding judges in all of the courts in the country, and they are directly responsible to that council. But however, they collaborate on a daily basis. And also the specialization has been achieved through the 7 departments. Another possible example could be Netherlands. It is a country of 17.5 million people, and as we can see, Netherlands has currently only 11 courts, so more than 1 billion people per 1 court. But these courts have also multiple seats and multiple locations. For instance, the district court in central Netherlands has 4 places where people can turn to, but operate within a single structure. And also in the Netherlands, a number of judges exist as a flying squad or a flying brigade, which can jump in wherever new problems and new cases occur, which are overloading the court system. So I will finish up just with the final question, and this is the question of transition. How to optimize current judicial resources for the needs of the court in the 21st century. We all know that we don't come from a vacuum, and every country currently has courts stuffed with judges, bailiffs, lawyers, and other ancillary stuff, and they have been inherited from the past. And, well, the European Judicial Scoreboard presents to us a couple of illustrative data which show what these structures look like, and we can see that these structures are fairly different. If we compare the number of judges and the number of lawyers per capita, we can see that there is almost 5, well, up to 10 times difference in such a number. So on the high side, what we can see here is that, for instance, the countries with the highest number of judges are Slovenia, Croatia, my country, Luxembourg, Greece, Bulgaria, and Latvia. And the countries with the lowest number of judges, well, these have up to 40, even 45 judges per 100,000 inhabitants. Denmark and Ireland have less than 5, while Ireland has only 2 or 3. Comparing number of lawyers is also interesting. The countries with the highest number of lawyers are Luxembourg, Cyprus. I think Cyprus is the country which is here together with Greece in the high figures, Italy, Malta, Portugal, and Spain, whereas the countries with the lowest number of lawyers per capita are Austria, Finland, Latvia, and Sweden. And, well, we can ask whether this shows that countries with the highest number of judges and the countries with the highest number of lawyers are also automatically the countries with the most efficient judiciaries, which handle the best the cases that they are being assigned to. However, if we just consult another slide, and this is a slide showing the public trust in judiciary in Europe, we can basically see that in about half of the EU countries, a half or more of population do not trust the independence of judiciary, and this can also be taken as a sign of lack of trust in judiciary altogether. What we see is that the high trust exists in Scandinavian countries, in the United Kingdom, in Germanic countries, Austria and Germany, and in the Netherlands, whereas the low trust mainly is pervasive in Eastern Europe, Italy, Spain, Portugal, and Greece. What can we draw from this as a conclusion? Well, I would warn that these figures at least tentatively indicate that the more is not the better. And that, well, just like with money, printing money hasn't increased the value of money, but it has led to inflation. And therefore, especially because we need in the future an adjustment to completely different types of work, taking into account all of the arguments which I was presenting before, we need to be very cautious in engaging only in quantitative reforms by addition of personnel on each side. And well, on this note, hoping that I haven't been too extensive and that you at least found interesting something of my speech, I thank you very, very much for your kind attention.